We are live.
Thank you. Good morning. Senate Judiciary, June 20th, 2023. We are discussing whether to concur or whether to override the governor's veto or to put the bill back into committee and rework it. We've had a number of concerns expressed by law enforcement, state attorneys, attorney general, victims advocates, and others. We've also had strong support from the ACLU, the Innocence Project, NAACP, both Rutland and Brattleboro. I believe there's another group involved in that as well. We're strongly supporting the bill. I've talked with the vice chair and we are meeting and we're happy to have Ben Novotelsky with us and back from his congratulations.
Thank you. Yes.
Being the family man he is, I believe by 1 o'clock to get to a middle school graduation or
Yeah.
Pretty active dad.
Yeah.
I have to say, I don't know how many of you seen the viral picture of the Red Sox game against the Yankees Sunday afternoon when the kid, that ball was caught and the kid gave it to the young kid who threw the ball out into the field. Dad was just mortified.
Right.
And then I guess the kid got 3 baseballs signed by Red Sox players and a shirt signed by somebody, but it was quite the Father's Day for that family, for sure. Anyhow, so the big concerns that have been expressed is targeted deception, whatever that means, and going to 18, going to under age 22. The bill was introduced was 18 and under, or under 18. So Ben, maybe you could just fill us in a little bit on targeted deception.
Well, that's a good question. I mean, I think, so for the record, Ben Dobrogoski for the Office of Legislative Counsel. From my recollection of the various law enforcement folks' testimony, I think targeted deception is really, and I think it is used in the context for those internet crimes. I think sort of the example that's being given is potentially being on a chat room and an investigator kind of posing as someone who's underage to essentially further the investigation. I'm going to leave it to my colleagues, though, the Department of State's attorneys to kind of elaborate a bit more. But I think that was a concern from the bills of being sort of hamstrung, so to speak, on their ability to do that investigation. Because if that work was done during the investigative stage and then a suspect is brought in a custodial environment, basically, could they use that deception, an officer potentially posing as someone underage in that custodial interrogation? But again, I'm going to leave it to my colleagues, the state's attorney's department.
So, help me to understand. So Essex applies to interrogations. So that would be a custodial interrogation. It wouldn't apply to the investigatory process, would it?
Yes, this bill applies to custodial interrogation.
So I don't understand how this bill would hamstring someone in any way from during the investigative process, posing in a chat room as someone who's underage. That person is not under interrogation. Is that correct?
Yes.
Okay, thank you.
Yeah, Tim, did you want to comment? And I'll leave.
Yeah, Tim,
if they want to comment.
For the record, actually, Attorney Dobrowski
You can stay right there.
did point out that point of your question, which is actually after the investigation is concluded, I know we have two former members of law enforcement here. And let's say the investigation is concluded, they've sort of collected up the evidence, and now they're bringing the subject into the interrogation phase, the custodial interrogation. So officers do then continue the quote ruse in that interrogation as well. You were talking with a person named this. You knew they were 13 years old. So the deception continues in the custodial interrogation. And it's not to get as Samantha Prince pointed out in Windham County at the community child advocacy center, it's very rare to get a full quote confession. Sometimes it's little bits and pieces, sometimes the admission of other victims or individuals they've worked with. But just to be clear, the investigation has ended. You're in the custodial interrogation, and that deceptive tactic, targeted deception, is still being used to continue the ascertainment of the truth, identifying victims, identifying other facts that might be important, including any co-conspirators. But that, to answer your question, it still does apply in that custodial interrogative phase. Matt Raymond, who didn't testify in this chamber, did testify in the House and said that they do use that in ICAC, the Internet Crimes Against Children. I don't know if that's helpful at all.
Not really, because I feel like if you looked at someone and said you knew they were 13, you're not deceiving them because they did understand that person to be 13. So that still is true. That person believed the person to be 13.
Right, but during the course of the interrogative interaction where they're in custody, first of all, they have a right to an attorney during that interrogation. They have a right to have another person there. And unless there's a huge list of exigent circumstances, that has to be recorded as well. So there are other protections in place. The person engaging in that conversation might have been the person posing online, and that might, for very good reasons, including the ascertainment of victims, not just ones that are known, but unknown victims. Is there, you were talking with person X. Is there other people you were talking with as well? To reveal and unveil the fact that it was a law enforcement officer they're talking with, they might shut right down. But instead, they're handing them screenshots of chats. This is the person you were talking with, right? Mm-hmm. To unveil that targeted deception, the potential for future admissions and a potential confession may fade away. And that's what we did hear from law enforcement and from statewide, the child advocacy centers, in terms of where they're still using it, particularly in the large population of up to age 22, as opposed to age 18. And to get to the chair's position, I think the concern for the bill started to grow when it went to the House side and the population went up to 22 and under. I think there was less concern with respect to.
No, that happened in this chamber. It passed out of the Senate at 22.
Indeed, where it started at the end as introduced, and then when it went over to the House, it sort of maintained that. But I know it was in this chamber, it went up to age 22, but went over to the House. That conversation continued about age 22.
Right. Well, they've made a number of changes, but the Conference Committee brought it back to the Senate version.
Yes,
I'm trying to understand targeted deception is a tool used. This is from the letter from various groups. Targeted deception in investigations of sexual assaults on campus, among other crimes. Targeted deception is a tool used with suspects in the 18 to 21 year age category to elicit truthful reactions about the suspect's own culpability, helping to identify victims and stop perpetrators of sexual and physical violence. The bill does not support community and victim safety, rather takes away a tool to address child exploitation and sexual assaults. So it seems like you want to be able to use targeted deception, you just described. And if you take away the 18 and 20 year olds, 21 year olds.
I have a question for council. My understanding of the Senate version, and it's ping-ponged around a lot, so I might need some clarification, is that the evidence gotten in a deceptive way, and I'm still not convinced that the targeted deception would meet the criteria, but if it did, that the presumption of inadmissibility can be overcome if there is evidence that it is still valid confession. I realize my language is probably not appropriate legal term, but that it does not actually say you can't use that. It says you have to prove that you used that in a way.
Right, I mean, there is a prohibition that you can't use those techniques, but there is a presumption that can be overcome by clear and convincing evidence in the Senate version.
So, and that's the version we're back at, correct?
Well, it's actually the conference.
The conference,
report,
yes.
but it's very similar.
Okay, and that's what I was trying to get to is that we sort of came back to that space that if during an interrogation, it was determined that the only way to continue that investigation would be to use that targeted deception, that they could overcome the presumption of inadmissibility in the court process.
Yes.
Okay, thank you.
Senators.
Ben, I was wondering if you could talk about the knowingly standard that's involved here and also, you know, and I don't want to beat a dead horse and go back to a previous point, but I'm looking at the definition of deception as well, which is deception includes the knowing communication of false facts about evidence. So if a detective is presenting to a suspect evidence that they have, which shows that they were engaged in a conversation with somebody that they previously believed was 13 or 14 or whatever age, but it was actually a cop. I mean, is that false evidence? Or can you go into that a little bit for me? And then maybe, Sam, if you have.
Yeah, I mean, I think the question, or the answer to your question is that it's going to depend. I mean, there was a lot of testimony previously about rapport building, and then when you look at the actual definition of deception, knowing communication of false facts about evidence, the knowing misrepresentation of the accuracy of the facts. So those are the things that you're misrepresenting, hypothetically, if someone is misrepresenting themselves as 13 years old when they're, you know, an adult investigator, what is that misrepresentation about? Is that to establish a rapport, or is that to kind of induce them to talk more about the facts, or is that in and of itself a fact of the case, that 13 years of age? So I think those are key questions about whether or not it's captured in the definition. I think you could make the argument that someone who's just building a rapport to obtain information through the free flow of a conversation probably falls outside of that knowing definition of deception. But again, it's fact dependent in each case and in the investigation and what really the intent is, and trying to obtain what the facts are. Are they trying to misrepresent a fact of the case? I think something that was explained or testified to previously by various law enforcement is, you know, this definition, this distinction between we have a rape kit with your DNA when you don't in fact have it. That would be a knowing deception. But I think it all depends on how that fact is presented. Presenting it that way, deception. But if it's posing the question to somebody, do you know if your evidence, or if you have DNA evidence from the site, or, you know, something like that, if you pose it as a question, it may not fall under that knowing deception because it's not being presented as fact. It's an inquiry. So I don't know if that really answers your question per se, because it really is a fact dependent issue, but hopefully that helps sort of explain the difference between what could be sort of rapport building or really an investigative question compared to presenting facts, or presenting false facts as a fact in an investigation, if that makes sense.
Yeah, thank you.
The ACLU would like to comment?
Not this time. No.
Okay, thank you. We do have a decision to make, really. Is do we want to go forward? Do we want to allow the governor's veto to stand and take the bill up in the next session and try to go through this process again? I think I'm only going to say that I respect all the groups that have come out against the bill deeply. I've always tried to work with them, state attorneys, the victims advocates.
If I might, sorry. I know
Center
this
for Crime
said-
Victim Services, Vermont Police Association. Pardon?
Sorry, I know I said I would pass, but I just, I would like to say something, for the record in showing here with the ACLU Vermont. I just want to say blanket that cops should not be lying to kids, and that is the basis of this bill. And, there has been a lot of back and forth, a lot of movement around this bill, and I just want to encourage us all to think about the purpose of this, and that is to raise the standard around what practices are being used in interrogation spaces. And so looking at the committee conference version, I think that there's a lot of compromise, and to move this bill forward, to prohibit deception for the next, I don't know, the year going forward, seems more in line with the values of our criminal legal system, I will say, than like prohibiting or ending this bill from moving forward at all. So I just want to say that the purpose of this bill is to raise the standard and to end the use of deception in interrogations. And if there's a way to like come back and think about this later on, I'm open to that. And I'm also, I think that this is a very important bill that needs to be done now. So I will leave it at that. Thank you.
Yeah.
Just a quick, to follow up, thank you, Indy, for your statement as well, I appreciate it. But to follow up with what you said, Chair, I also have a lot of respect and appreciation for all the stakeholders who voiced concerns. One of the somewhat frustrating things is though that we've heard a lot of the concerns, you know, literally on the final days of the session, which did not leave us a lot of room to maneuver and try to address those concerns in this chamber. And I know there was a lot of testimony in the House, but it definitely would have been helpful to have gotten some of those concerns earlier on. So I just wanted to share that.
Senator Bowles.
So while I think the number of people sharing concerns grew towards the end, we actually did hear a lot of these concerns when we were debating the bill in this chamber initially. And we chose to move forward with this bill because of the compelling evidence we heard that this type of practice overwhelmingly impacts people under the age of actually 26. We already compromised on the age to 22. And that they lead to false confessions, which puts people who have committed a crime back out on the streets and does incredible harm to people in some of the most formative years in their life. Since we've adjourned, I've also learned about instances where law enforcement use deceptive tactics to get assault victims to recant their allegations. So this can be used in many different ways that are really harmful. And I think it's also really important to remember that the International Police Training Association has come out in opposition to this practice in a blanket way. They have said that this practice should not be used at all, not simply with people under the age of 22. And that almost every European Union country has banned this practice in a blanket way, beginning over 2 decades ago. We are so far behind the 8 ball in rebuilding trust in our communities. I think I'm frustrated because I feel like we went back to a Senate version where we heard these concerns and made a chance to move forward. And when it came out of the Senate, people were not excited, but seemed somewhat neutral. And so I guess I'm confused why, now that we're back with the Senate version that people were somewhat neutral to, now it's a problem. So I'm also frustrated, but for different reasons.
Well, the governor vetoed the bill.
Yes.
That's why we're here.
Oh, I know.
Yeah, I mean, I didn't veto the bill.
I know you did. I know you didn't, Senator. I'm not frustrated with you.
Thank you. I want to accommodate the concerns expressed. I was looking at the effective dates, effective July 1, 2023, so goes into effect in a few weeks. So let's see what we want to do.
So, can I just?
Yep.
mention something, Senator Chair? So if you look
Yeah.
at, what passed in the conference report, section 4, which is, I think, what you're primarily concerned with, the policy around that does not take effect until, April 1st of next year.
What am I looking at? Oh, I'm looking at the House calendar.
So if you look at section 9 of your conference report, so you have the act taking effect on July 1st of 2023, except that sections 4, which is the juveniles, section 6, which is the council services contingent on agency compliance and grant eligibility, and then 7, which is the statewide policy. Because remember, in part of your discussions with the House during the conference committee is you tied the compromise that you made with the House because of your concerns with some of these witnesses who are coming forward now, that you tied, you bumped out the effective date of the juvenile section to be the same date as the date that the law enforcement agencies are supposed to have their policy, so that they would have a model policy in place as required by another section before the section 4 would take effect. So.
I was reading the House. Reading the wrong thing. Thank you. So I'm glad that you clarified that. So there is time before this act takes it back to code. Yes.
I thought that was Tim Leaders came on for the record, and Attorney Childs, I thought that was the model policy start date. I thought that the immediate, as our colleague from the ACLU was saying, I thought the prohibition on deception, the new suppression process, I thought that would go into effect on July 1st. Is that not the case? I thought
That's not the case.
so everything would go into effect next year.
Not everything. The model policy is for April 1st, as well as the section 4, which is the statutory change to juveniles and the no lives of anyone under 22.
So it's possible if we decided to do that to deal with it next. Anyway. And if the pro tem okays it, I'm happy to work on the bill in December. If the pro tem okays it, I'm happy to work on the bill in December.
Absolutely.
So,
By work on it, you mean if we don't?
we'll look at whether or not under 19, I think you have to be consistent with our juvenile law, which is either you go with 22 or 19. I mean, these are all issues. And whether we create an exception for targeted deception, which is the internet crimes issue. I believe that's what would be left. Am I missing something, Tim?
You know, I think that would be a reasonable starting place, and Executive Director Campbell talked about the age range being one of the broadest points of concern, just being such a large population. But the ICAC exception, I think, would be something that was discussed in committee in the House as well, so there might be some agreement there as well.
Yes.
I have really big concerns opening this back up. I already think the bill has been weakened to a point that feels uncomfortable to me. And it was a compromise that I felt like I could agree to protect some of the people most impacted by deceptive interrogation practices. I'm not convinced that the ITEC exception is needed based on what I've heard from legislative counsel in when this would apply and when this wouldn't apply, or how it would apply. Especially given the conversation around the false representation of evidence. If someone is putting in front of you, you had this chat, that's not false representation of evidence, that is the evidence. Mm-hmm. So I'm not convinced that is needed. And as we know from the statistics that, as you know, I'm very consistent. The statistics I have put into this room over and over and over again, the vast majority of false confessions obtained through this practice happen between to people between the ages of 18 and 25.
Let me make clear what I'm proposing we do. I'm proposing that we override the governor's veto.
Okay.
And recognizing that this section of the law does not take effect until April 1st? Or July 1st?
I'm sorry,
When does this section 4 take effect?
it takes effect on April 1st, 2024.
And I'm suggesting that I will introduce legislation that would lower the age to 19, under 19, because we've already raised the age. And that we look at some legislation on targeted deception, whether it would be a decision of this committee if we go forward with the bill.
Okay.
But
So this bill would still
this bill would,
move forward.
well, I mean, assuming that we have the votes in the Senate, assuming we have the votes in the House.
Mhm. Okay, thank you for that explanation. The last piece I wanted to make is I think it's notable that Minnesota is actually debating a bill right now that would ban deceptive practices for everyone, no age, period. So that's all I have to say. I think I can
I
support
think we
that.
have to know what deception.
I appreciate your clarification. I can support that.
If I might add as well, I know that Connecticut just passed a bill
Yeah, I
that is very close language to what we have now. I'm not sure about the effective dates, but I think that's something that we can.
Well, obviously, I was looking at it, the version that the House sent to me during the conference, and I
Section 3 is just
was looking at the wrong
Section 4.
actual version that we agreed on, which was on April 1st. So Ben, if you would, I don't know if there's any other issue. Those two issues seem to be paramount in the concern of the law enforcement and victims groups.
That was my understanding as well, based off of the letters that were submitted in the veto letter.
Yeah, if you kind of go over that letter and see what we
Parse out
put
for
together,
November.
and I have some legislation and any member of the committee which is doing that. Well, my suggestion is we vote to override at this juncture, with the understanding that I'm committed to coming back to these issues and allowing law enforcement to make their case. And hopefully getting a quick vote out of here anyway in the House. Let those folks who are advocating for these changes, if they pass the Senate, that they would recognize the need to work in the House to get it done before April 1st. But as originally introduced, the bill was 18 and under.
Yes. So I guess I'm a little confused here at this point. First of all, I wasn't prepared to go to committee. So we wouldn't have, the wheels weren't quite turning to come in here. Not that they have been in the past, but I don't think it's a matter of leaving politics out, that vetoing or not vetoing, whatever else. From listening to, the attorneys and the special interest groups and law enforcement, my concern is just talk. Did I do due diligence on this bill here with all the unknowns that seems to be going forward and whatever else? Or is this something that, and I know, Senator Bohski has her thoughts and everyone has their thoughts, but I guess I'd probably feel more comfortable saying, okay, let's just slow the train down here. Let's just bring the bill back to the committee here, leaving politics out, to say that it's our responsibility to do due diligence on this bill here. And there's a lot of questions still hanging out there, I guess, from all parties involved here.
Well, I'm going to respond with, I think it's important that we have in law some of the sections regarding, the definitions and so forth. I still think it's important within law that we create a model policy on interrogation, that we have at least consistent policy around the state, and holding off another year on that creation of a model policy is troubling to me.
I like the model policy portion of it. I agree with that, but I haven't seen it as of yet. Okay, that's my concern that I have.
What?
The model policy, interrogation policy. We haven't seen that as of yet.
Well, they haven't been directed to do it yet.
this bill directs them to do it by,
But there's other things in the bill also that direct certain things too. That's what I'm saying is I want to see the model policy for it.
sending them.
My understanding though, because we've had the effective date conversation, is that this bill doesn't take effect until we have the model policy, correct?
Correct, so the section directing them to develop the model policy takes effect July 1st of this year. And then they're required to have adopted, all the agencies to have adopted a model policy by April 1st of next year. And then on April 1st of next year, when they all have a policy, then the substantive provisions directing no lying to under 22.
So we would have had time to have seen that model policy by then.
Yeah.
Yeah,
But even if we see it, do we have any say in it?
yeah.
Well, we will
Yeah.
be in session.
We'd be in session, so we'd be able to.
I mean, I think it could certainly be, Ben can't predict what would be in it, but we can put something in there to, so that it's germane to the bill. I guess it would be automatically, because the bill deals with deception. Then the model policy becomes part of it.
So no matter what we do here, we're still going back on the floor and voting on the veto, right?
That's the suggestion from the chair.
Okay, then let's do it.
Yeah.
So I just want to say, I support overriding the governor's veto. I think we did do due diligence. I agree with Senator Kovsky. We did hear a number of these arguments. In a weird way, this discussion is reminding me of the ban on chokeholds. So we came in with a very clear statement that we, following the death of George Floyd, that we wanted to ban the use of the chokehold. As we got into it and toward the end, there were some voices from law enforcement that were creating very, very hypothetical situations in which someone might conceivably need to use a chokehold in order to remain alive themselves, although that wasn't really at issue in the bill. And here I feel like, again, we're funneling down to a very particular circumstance in which deception, so online predator cases, for instance, might be part of the official practice. But I think if you step back and you look at the language, it's just saying you can't threaten people with physical harm or deceive them in a custodial setting if they're under this age. And that seems to me just such a clear principle that I would vote to override the governor on that. And then I take the chair's suggestion of action at the end of this year, the beginning of next, if necessary, as a possible corrective to any negative consequence. So that seems to me like the best way to go.
Yeah, we won't, I mean, it doesn't take, the juvenile piece doesn't take effect till next April 1st, so there's plenty of time to make adjustments. I mean, it will be up to to convince the House to pass whatever we pass, if we do pass something in that new bill. But I would, Peggy just left, so somebody has to.
I can take care of it.
Oh, good, yeah, you're the clerk, you know how.
Yes, once we're done, I can take care of ending the meeting.
So you have to call the roll.
I mean, if we're not unanimous, that's okay. We don't have to be unanimous, but I know the vice chair has some concern and Senator Norris has some. So,
The one other thing that I want to be certain of is that we have the votes on the floor to pass it, and I believe we do. So, with this committee's recommendation, I think we can vote it out of the Senate. I did have a quick conversation with Representative Lalonde. I don't think it'll founder there. So, this seems to me a viable path.
so I'm not gonna take a roll. I'll vote all on board. But I will say the majority of the committee supports overriding the veto.
Do we know
Huh?
that? Do we know that without a straw poll or something here? I mean,
Well, I saw the faces. Senator Wachowski was clear, Senator Baruth was clear, Senator Sheen has not been clear, but I saw his face. And it looked like.
Yeah, keep my cards close. Yes.
He keeps It keeps everything.
I would
close
vote to
the
override,
vest.
yes. I would vote to override, yes.
Yes.
You've seen my face, right?
I've seen your face too, Senator.
I don't know, you've got a pretty solid poker face there, Senator Norris. All right.
All right, well, that was all.
That was fun.
Michelle, thank you for,
Do you want me to take us out live?
yeah, please.